My name is Bill Orth with the law offices of William S. Orth.
Hi, my name is Bill Orth with the law offices of William S. Orth. I'd like to talk to you about violations of probation. When somebody gets arrested for a criminal charge, if they're convicted of an offense later on through the court process, sometimes they're placed on probation, either county probation or probation through the Department of Corrections or for felony cases. When you're put on probation, it's for a length of time. It could be 6 months, it could be 12 months, or even longer than that. You can either have a technical violation of probation or a violation of probation which is based on a new law offense. Technical violations of probation are things that involve technical items within your probation order. That could be not showing up for a probation appointment, not paying your court fines and fees, or anything else that doesn't involve a new law offense. The second, as I stated, the second type of probation violation could be if you've committed a new law offense, because an order of probation is always that you remain at liberty without violating the law. Regardless of what you do to violate your probation, the court may issue a warrant for your arrest. What that means is the police are going to come to your house, possibly with your probation officer, and you may be arrested. In the state of Florida, if you're arrested for violation of probation, you're not constitutionally entitled to a bond for that charge. What that means is essentially, unfortunately, you may sit in jail until you go in front of a judge for your violation of probation hearing. The judge does have the discretion, though, to issue a bond either in the charge, or they may, instead of issuing an arrest warrant, issue what's called an order to appear, which is basically a summons telling you that you have a court date and you have to be in court on a certain time. The standard of proof for violations of probation is preponderance of the evidence. So it's a little different than a new criminal charge. A new criminal charge, the standard of proof is beyond a reasonable doubt. Violation of probation, in order for your probation to be violated, the state has to prove beyond a preponderance of the evidence that you committed that specific violation. But the state, most importantly, has to prove also that your violation of probation was willful and substantial. That comes into play many times with cases where people whose probation is violated for financial reasons, not paying a fine, not paying court costs, or something along those lines. The state has to prove that you had the ability to pay and that you chose not to pay that. That goes along with the standard of a willful and substantial violation of probation. The law states that it's not a substantial violation or a willful violation of probation if you're violated for monetary reasons and the state hasn't proven what they need to prove. If you have more questions about violations of probation, feel free to contact me at my office, 407-772-0000, or you can email me at worth@williamorthlaw.com.